Correct. And if you thought that the C1D2 language were sufficient to authorize cumulative punishments on its own, then that would mean that the language I was just pointing you to in C1A would be superfluous. And that's a superfluity that would have existed at the time Congress was enacting the statute.
But I mean, superfluity is usually defeated by notwithstanding any other provision of law. But I understand your argument on that, and I understand Justice Jackson's point. I think the Second Circuit was quite reasonable in what it did in the wake of Laura. Let me ask you another question. Does this matter from the government's perspective in terms of sentences that will actually be imposed in the real world in cases of this nature?
So I think likely not in practice.
That's why I assume you're where you are.
The government is going to have the ability to dismiss convictions or to dismiss the guilty verdicts that it gets on certain counts before sentencing happens. And so it can have the ability to choose, I think, which of the counts the sentence is imposed under. And that might take into account the sentencing exposure that we think is going to occur under either J or C, and we can choose which one we think is the more appropriate under the circumstances.
Do you think that there are cumulative punishments